In 24-360, Deutsche Bank Trust Company American versus John Kendall. We are being streamed live on the web, both by audio and by video. What I would ask first is that counsel for both parties identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good afternoon, Justices. My name is Brett Messenger, and I am from the law firm of Duane Morris, and I act for the appellant, Deutsche Bank Trust Companies America, as trustees.
Good afternoon. Alicia Curtis for the defendants, appellees Sherman Kendall and John Kendall.
Okay, thank you. And Attorney Messenger, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court. My name is Brett Messenger of the law firm of Duane Morris. This is another foreclosure case that has at its center the issue of standing. Since this court's decision in Greenleaf and its limitations on MERS to execute assignments of mortgages, Maine has taken a bit of an unusual path. When MERS is involved as a party to a mortgage, we are required to go back to the originator of the mortgage and provide evidence to tilt the scales to show that it is more likely than not that the foreclosing plaintiff has standing to enforce the mortgage. It seems that many trial courts have lost direction on the burden of proof and have raised the bar such that many foreclosure cases are lost at the time of trial. In proven standing, there are issues relating to the note and other issues relating to the mortgage. In the trial in this case, there were no issues relating to the note, as there were a series of endorsements that were affixed to the note that shows it being transferred from the originator of the mortgage to a company called Residential Funding, then to Deutsche Bank as trustee, and then to the plaintiff. The mortgage provides a similar path of assignments, first to the plaintiff, but since that was executed by MERS, something more was needed, even though the assignment may provide, as this court has held, some evidence in regard to the standing. In addition to the MERS assignment, there was also a quitclaim assignment from the originator to the plaintiff in this case, and that quitclaim assignment has been held by this court by numerous opinions to be a method to establish standing to enforce a mortgage when MERS is involved with the mortgage. The reason why the quitclaim assignments are a good way to establish standing goes to the concern that a plaintiff may be subject to multiple enforcement claims. The quitclaim assignment takes, like a quitclaim deed or anything else that quitclaims property, lets all that looks into the public records to know that to the extent that there's any interest that's possessed by that person providing the quitclaim, it's being transferred over, in this case, to the plaintiff. But that's where the trial court lost its way. Specifically, there was a question regarding the validity of the power of attorney used to execute the quitclaim assignment. The court somehow believed two things. First, that because the originator of the loan went through bankruptcy and was no longer in existence as a result of it, the power of attorney was no longer valid. But on this issue, the power of attorney was executed as a result of the bankruptcy proceeding itself. Counsel,
I see that the green light is on. Let me ask you this. There's a couple things I think you will agree. That the POA needed to still be effective and grant Ocwen the authority to transfer in order for the quitclaim to be effective, correct?
In order for the quitclaim to be effective, just like anything else that's filed of the public record, you have to have the authority to execute.
Right, so the POA had to still be effective.
The POA had to be effective, correct.
In addition, a quitclaim can only transfer what is owned. So in order for that to be effective to transfer the remaining interest, that remaining interest still had to be owned by Homecomings Financial, right?
Well, I think that's where I would disagree with you.
If Homecomings Financial didn't own anything, is this sufficient?
So a quitclaim, by definition, is always the same. It's saying, to the extent that I have
I
an
understand.
interest of that property, I'm transferring it to whoever the new beneficiary interest. Now, remember, the reason why we use quitclaims is so that if there's any doubt in regard to the beneficiary interest in a particular risk, right, it's basically saying, to the extent that there's anything there, I'm transferring it to someone else. And the reason for that is the underlying concern with standing always has to be, when you're talking about a note and a mortgage, is you don't want that same plaintiff to have to fight another claimant under that same instrument. And that's why we endorse notes. That's why we're concerned with having possession of the original notes. And the same thing is true in regard to...
I understand all of that, counsel, but I think what the purpose of the quitclaim, and the reason we've said that's okay, is that together with the assignment by MERS, in theory, should get all of the interest into the plaintiff in this case, is what you're trying to accomplish, correct?
That is correct. I wouldn't say it that way, but that is
Okay.
correct.
So here's my question. Do you agree that if the 2017 quitclaim is not valid, then there is a basis upon which to find that the plaintiff did not have standing?
I would agree with that. Just like anything that's signed without authority
And
wouldn't have any effect.
if the documents contained in Exhibits K and I are not considered, take them out of the equation, does the remaining evidence compel a contrary finding to what was done here? I understand you disagree with the conclusions that the court made, but my question is, does the remaining evidence compel a contrary finding?
It does. First of all, just to be
Why?
clear, I'm going to answer your question. Just to be clear, Exhibit K was admitted into evidence.
Well, for very limited purposes,
Right.
and we'll put that aside.
Yeah,
My question is
the
if they're
reason
not.
is that on the face of what we have a limited power of attorney. The limited power of attorney is self-authenticating because it's filed within the public records, which is also established at the time of trial. What we're doing is we're having a collateral attack, and the collateral attack on the limited power of attorney was based upon two things. There was only two things that was based upon. First is that there was an admission that was agreed to at the time of trial that Homecomings isn't authorized to operate business in the state of Maine only. And second, it was based upon the fact that there was a bankruptcy filing, right? Those are the two things that it was based upon. Neither one of those things should tilt the scale back the other way in regard to the challenge of the limited power of attorney. The limited power of attorney was a self-authenticated document. It says what it says. And there was an argument only in regard to whether a limited power of attorney would die with them not being able to operate business within the state of Maine, or die because of the bankruptcy proceeding. None of those two things are correct. As I pointed out in my reply brief, is if bankruptcy means the inability, and by the way, there's no evidence, zero, that the limited power of attorney was rescinded like you can for any limited power of attorney. There's no evidence of that. So the court's basis of determining that the limited power of attorney was no longer in effect was those two things I just said.
Can I ask you about the evidence, what was before the court, what the court was relying upon? We have the concept of judicial notice. You asked the court to take judicial notice of the certain pleadings and documents involved in the bankruptcy case.
Yeah. So,
and as a matter of law, that establishes that, in fact, they were filed. They were asserted in the litigation to establish the fact that they were there. I guess Exhibit K was admitted, but Exhibit I, the I exhibits, were not expressly admitted by the court.
that is correct.
So can the court rely on anything that is in those non-admitted exhibits?
Well, it can, because part of what's well, can I first speak to Kay? So Kay was admitted, right?
Right.
And what did Kay show? Kay showed that within the bankruptcy proceeding, that as part of the bankruptcy disposition, the servicing rights were sold from the bankrupt estate and purchased by Ocwen. As part of that, those same Exhibit K show that there was a limited power of attorney that was going to be issued, and in fact was issued to
Right,
Ocwen
so
Loan
the
Servicing.
K exhibits are in evidence.
Okay,
the
so let me go
content.
back to I.
For
Yeah,
limited
good.
purpose.
So
For limited purpose.
So the reason for I is, can this court consider that? The answer is yes, if you find that the trial court should have admitted them. Now, if we go back
But
to...
not to interrupt you, but I guess I am interrupting you.
That's all right.
At one point, the court said, are you going to move these into evidence? And Deutsche Bank said, no, not, we're going to get some more foundational testimony. And that was the end of that. So it was never, I was never admitted.
But in regard to, well...
It was never even proffered.
Right. That's not exactly correct, because in regard to Exhibit I, if you will recall, is that the court did reserve its decision on whether it should be admitted or not, and then ultimately the court made a determination that Exhibits I, there's actually 3 of them, I, 1, 2, and 3, Exhibit I shouldn't be admitted. But the reasoning for the court not admitting those was basically that they were hearsay. She found that they were hearsay.
Wasn't the reason they were not admitted because they weren't proffered in the trial
I don't
itself?
think that's right. I think that the record will reflect that they were proffered for admission, and that the testimony that you're talking about is that they were relying upon the previous testimony. The court did
All right,
take it
I'll
under...
check the record on that.
Yeah, check the record on that.
I'm basically steering you back to the Chief's
Yeah.
question, which was, let's assume I can't be relied upon by the court because it was never admitted into evidence. Do you have enough horses to pull the wagon without I?
Yeah, so
Why?
first of all, here's what I believe, and I think it's right, is that the limited power of attorney by itself, which no one contested, right? Because we admitted a limited power of attorney. Even the defendant took another version of that same limited power of attorney and moved itself into evidence. There has never been a challenge regarding the genuineness of that limited power of attorney. So then when we go back to what Exhibit K, so I think just on its face, there hasn't been a challenge to the limited power of attorney, and certainly it allowed for the execution of the quitclaim assignment. But even if we have to go beyond what that is, you look at the bankruptcy documents. The bankruptcy documents, which were admitted, not challenged on this appeal, were admitted in evidence. By the face of those, it shows evidence why that limited power of attorney actually exists, and the reason why it exists. I know I'm on yellow. The reason why it exists is because it was part of the transaction. Ocwen Loan Servicing bought servicing rights. If they
How do
didn't,
we know, let me just ask this fundamental question. How do we know this specific mortgage was part of that process of what was purchased and
Well-
therefore was subject to being transferred?
well,
pursuant
that's
to
a
that
great
limited-
question, because that actually goes back, right, to sort of the other evidence here. So we do have a MERS assignment. I know that's not good enough for standing, but it is evidence that the loan was, because there is an assignment into the trust here, the plaintiff here. So when you look at that, that can't be evidence of standing, but it can be evidence of other stuff. And the other stuff is that that loan was deposited in the trust. Of course, we know from Exhibit I that wasn't admitted, that loan is actually
Which means we
part
don't
of-
know it from there, so.
You're cutting me off, okay.
Well, it also means we don't know it from Exhibit I, was my point.
Okay.
Yes, the time is up. Thank you.
You're welcome, thank you.
And Attorney Curtis.
Chief Justice Sandfield and your honors, may it please the court. I'd like to take my reserved time to review some of the facts about Exhibit K and the I exhibits and the colloquy at trial. So with the I exhibits, Deutsche Bank asked only that the court take judicial notice of the I exhibits, and that's in the trial transcript, November 2nd, page 188, lines 3 through 4. There was no request for admission as a business record, and at no time at trial or in the bank's closing brief did the bank mention anything about admissibility as a verbal act or admissibility for any other reason. So the court said, well, I'm going to take that under advisement. At the end of the trial, the court specifically warned there's been no foundation for the business records exception to hearsay. There's simply not been laid. The court took it under advisement, but warned that if I don't find the basis for judicial notice, it will be excluded. And that's November 28th, that's page 11, line 17 to page 12, line 7. So in the bank's closing brief, despite the fact that the court gave a clear warning there had been no foundation for admissibility at all, and the court was taking judicial notice under advisement, in the bank's closing brief, the bank only said, this is on app 139, the bank only said about Exhibit I-3, well, it assists in understanding the mortgage service process, but is not relevant to the elements required for foreclosure. So at that point, the bank waived any argument about admissibility because under Evidence Rule 402, irrelevant evidence is inadmissible. In the court's order on app 37 and 38, the court said that the court did not address the I exhibits because the foreclosure failed on other grounds. But then when the bank filed a post-trial brief, the bank did not address the I exhibits at all. So only in the bank's reply in support of a post-trial brief, which is app 204 and 205, did the bank raise that. And so in app 208 and 209 is for the first time in the reply brief, at which point they have waived this argument because it appears only in the reply brief, did the banks make the arguments that they're admissible because they're non-hearsay contracts, or that the court is required to take judicial notice of SEC filings. That was not an argument made in the trial below. And so in the court's order on the post-judgment motion, the court specifically found that all arguments about admissibility had been waived. And so that's why in the post-trial order, the court only considered judicial notice of the I exhibits and ultimately did not take judicial notice of the I exhibits. And as to Exhibit K, as the court has mentioned, Exhibit K was not admitted in the sense of admitted for the truth of the matter asserted. Exhibit K was, there was judicial notice taken of the fact of a bankruptcy filing. But the court specifically said this is for the limited reason that it will not go to proving title to mortgage. It's just for sort of a limited purpose of providing some context. So, and I waive the rest of my time.
Well, looks like it's up anyway. Let me ask you this. In this instance, the Exhibit K, and for that matter, Exhibit I, were asked to have the court at some point, maybe not timely, it may be waived, but putting that aside, asked to have the court take judicial notice. Does there have to be some kind of authentication of documents besides just sort of having the lawyer hand them to the judge?
It's always fundamental that the proponent of the evidence has to say that the document is what it purports to be. And one of the prerequisites in Maine Rule of Evidence 201 is, first of all, that it's a fact that's not subject to reasonable dispute, and you have to give necessary information about the document. And it's that necessary information that really provides some reliability and authenticity to the document.
It's been suggested that these were self-authenticating documents. Do you agree with that statement?
I do not.
Care to elaborate? Or do you feel elaboration is necessary?
I don't feel elaboration is particularly necessary. I will note that there was no context provided. So, for instance, for Exhibit I, it was just stated these are from the SEC website, and there was no context about where on the website. The pooling and servicing agreement in Exhibit I was unsigned. So that would be, to me, sort of the opposite of a self-authenticating document.
Take me through, if we don't consider essentially Exhibit K for anything other than the fact that, a bankruptcy existed, and Exhibit I is not considered. What is the evidence from which a judge could find that the 2017 quitclaim didn't transfer the interest it was purported to transfer?
Well, there are a number of holes in the evidence, if you will. There are sort of three important holes or missing links in the evidence. If the evidence were a wall of bricks, there's quite a few bricks missing here. And so the missing pieces are that there's no evidence that the 2013 power of attorney was still valid in 2017. There was evidence about the bankruptcy.
There's no evidence that it was revoked.
There's no evidence it was revoked, but the trial court sat through 3 days of evidence. The trial court heard everything, sort of listened to the witnesses, listened to the credibility of the witnesses, listened to all the sort of the evidence as it comes in at trial. Sometimes it's not always as clear as it might seem in the appellate record, but it has a context and a sense at trial. And so the trial court was sitting at fact finder. As the fact finder, the trial court drew inferences about the bankruptcy. And one perfectly reasonable inference to be drawn about the bankruptcy in the absence of any further information was that the power of attorney was simply no longer valid post-bankruptcy. And that's supported by the law. That's supported by basic principles of agency law, that the agent has to be subject to the continuous will of the principal. Like when the principal is no longer, when a corporate principal is no longer in existence, the corporate principal cannot be subjecting the agent to his will. So, it was supported by the law. It was supported by perfectly valid inferences. Interestingly, in Beale Bank, this court, and it was dicta, but this court noted in a footnote in a very similar situation where an entity that had held a mortgage went into Chapter 11 bankruptcy. The Beale Bank court noted in that footnote that there was no evidence that the bank that purported to get the mortgage title from that entity that went bankrupt, said, well, there was no evidence that it still continued to exist. And it was a perfectly sort of rational inference to this court, even though it was dicta, that when an entity goes into Chapter 11 bankruptcy, that it no longer owns the property, and any power of attorney would no longer be valid.
And that's consistent with the restatement third on agency section, what is it, 3.07?
Yes, Your Honor.
D.
Yes, Your Honor. And so the other hole in the mortgage, I mean, there's sort of a hole in the evidentiary wall of bricks in that there's no proof that the power of attorney was still valid. There's a hole in that absent exhibits I and K, there's no proof that Homecomings owned anything. And again, the trial court could rationally infer from the fact of the bankruptcy that Homecomings ceased to own any assets after the bankruptcy. And Exhibit K was, the court took judicial notice of Exhibit K only for limited purposes, but if the court had looked at Exhibit K, it does refer to liquidating trusts. It refers to liquidation. It's a rational inference that the court could have drawn. The bank still continued to have the burden of proof. It had the burden of proof all the way through, and it didn't meet that burden of proof. It didn't convince the court. But probably the most serious gap or hole in this evidentiary wall of bricks is the fact that there's no evidence outside Exhibit I to show that the power of attorney covered the Kendall mortgage. The power of attorney itself references 12 large companies with mortgage assets all over the United States. There's nothing in the power of attorney, which is in the record, there's nothing in the power of attorney that references the Kendall mortgage. It only references a document that's found in Exhibits K or I. But without that document, it admitted into evidence for the truth of the matter asserted. There is no evidence whatsoever that the power of attorney covered the Kendall mortgage. And without the power of attorney covering the Kendall mortgage, there was no power to use to sign the quitclaim assignment and transfer the Kendall mortgage.
Let me ask you this. If we agree with the trial judge below, that on the facts and on the evidence could find that there's no standing, The judge entered a judgment in favor of the Kendalls. Do you agree that under our jurisprudence, if the basis of the judgment is a lack of standing, it needs to be a dismissal and not a judgment in favor of the Kendalls? I understand you've argued some alternate basis, and I'll get to that in a moment.
I'm certainly not asking this court to disregard Greenleaf or to overrule Greenleaf. That's not what we're here to do today. I agree that in the normal course of events, when a bank hasn't proven standing, that in the normal course would be a remand for dismissal without prejudice. And I know you've posited some reasons why it could have been a judgment in favor of the defendant, but do you agree that standing was the only basis that this judge in this case used? I agree that the only basis that this judge in this case used was a failure to prove title to mortgage and on the merits. So that's what we contend, is there was a failure of proof on the merits. And the Greenleaf case distinguishes very carefully, makes a careful distinction between the issue of standing and the kind of proof that's required for standing, the proof that's necessary for the bank to get into the courthouse. It's really is a preliminary burden of proof. You need.
But we've done that after trial too. Said it needed to be a dismissal.
Yes, and Greenleaf was after trial, but notably Greenleaf was a MERS assignment. So just right on the face of the power of it, right on the face of the documents, it was clearly under the precedent in Saunders, the MERS assignment was not going to hold water to transfer the title to the mortgage. Here, this is a 3-day trial in which there's evidence considered outside the documents, evidence about the bankruptcy document, and also just a failure of evidence, a plain old failure to produce evidence, so that there's
any cases where we have said after trial a failure to produce sufficient evidence of standing can result in a judgment for a defendant? And I ask that because I happen to know I got flipped on that. But
a failure to produce evidence can
on standing.
On standing.
Yeah.
So the issue is, was this failure to prove title to mortgage standing, or was it on the merits? This was a decision in which the judge said, by a preponderance of the evidence, he was not persuaded. And the Greenleaf Court is very clear. I'll read it to you. It says, first in paragraph 8, it says, the same statutory provisions that govern standing also provide a basis for evaluating a foreclosure claim on its merits. So we haven't until now clearly distinguished between the issues of standing and proof, but we do so now. And then in paragraph 22, note 13, the Greenleaf Court says standing just requires a minimum legal interest in the mortgage, whereas proof on the merits is what evidentiary burden the plaintiffs must satisfy to obtain a foreclosure judgment. So that's the kind of proof that you need to get the keys to the Kendall's house.
That leads me back to my question, do we have any cases where we have approved after trial, based on the evidence, of failure to persuade by preponderance that the person or that the plaintiff had the requisite interest in the mortgage, that after trial, have we ever approved a judgment on the merits for the defendant versus a dismissal?
I'm not aware of any.
The judgment itself says, very last sentence, because the plaintiff has not met its burden to prove standing, the court does not address the other elements of standing or the merits. It goes on to say judgment enters judgment for the defendant, of course, but that seems pretty clear that the court was only addressing standing.
This court may affirm the judgment for any reason, even not articulated in the order. And so regardless of the reasoning or the way that the trial court labeled certain things. But
many of the bases that you've talked about, i.e. conduct and litigation and things like that, those are really factual questions and given to the discretion of the trial judge. I mean, we wouldn't do with something like that would require factual findings and discretion without, I mean, we do it when it's a legal issue that provides a basis.
Right, but certainly in terms of affirming, it was the trial court who sat as a fact finder through 3 days of trial. So for this court, this court can affirm that judgment for any reason. And so this court, there are certainly a plethora of, there are a number of reasons laid out in the brief as to why this court could affirm.
Thank you. And Attorney Messenger, I believe you reserved 2 minutes for rebuttal.
Thank you. So just to answer your question, which I'm not sure it was answered or not, has there been a ruling by this court or any other court in regard to if stand-in isn't proven, does that result in a final judgment on the merits? And I think even in the most recent cases that this court has issued, the answer to that is no. So even if I lose here, and as was pointed out, as the judge actually said that in the opinion that there was no determination on the merits. I just want to go back to one of the things that I was, hopefully I hit home, is just in regard to the power of attorney that's at issue here, is the only evidence that was presented to this self-authenticating recorded document was that there was a bankruptcy and that somehow.
Was there any evidence, specific evidence presented to the court that showed that this power of attorney delegated the power to deal with this specific mortgage?
Yeah, there is, because if you look at the power of attorney, yes, it talks about a whole slew of different trust and beneficiary rights and that were possessed by the person who gave the power of attorney. And in regard to that is, I promise you I had my do not disturb on, but and if you look at that, it says, it names
Deutsche
this,
Bank,
yeah,
pool, blah, blah, blah.
Exactly.
But how do we know that, I don't know what's in those pools 3 years ago?
Right, but when you look at a power of attorney, right? When you look at a power of attorney, it's valid on its face. And if it's a defense to whether or not that power of attorney is no longer effective, that wasn't raised in regard to that. And that's like everything that we do in life in regard to, people go to closings with powers of attorneys and then we try to enforce the mortgage. It's never an issue as to whether or not the person 20 years ago had the authority to do that. Powers of attorney are self-authenticated on their face.
Thank you, counsel. As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. With that, we'll be in recess on this matter.
All rise.
The matter before the court is Andersen versus the Department of Health and Human Services, Cumberland 24394. And we are being streamed live on the web, both audio and video. If the attorneys who will be arguing would identify themselves by saying their names for the record, together with the party they represent, starting with the appellants.
Danielle Quinlan for the appellant, Sharon Andersen.
Jeremy Carter, Assistant Attorney General for Maine Department of Health and Human Services.
Thank you. Attorney Quinlan, if you would like to proceed, we'd be happy to hear your arguments.
May it please the court. My name is Danielle Quinlan. I'm here on behalf of the appellant, Ms. Sharon Andersen. There are currently 3 issues on appeal. The first is whether the harassment was based on Ms. Andersen's disability. The second is whether the hostile work environment, the harassment, was severe and pervasive. And the third is...
I'm sorry, I couldn't hear what you just said. Whether what?
Whether the conduct was severe and pervasive. And the third is the timeliness of this claim intertwined with the constructive discharge claim. I'd like to start with the timeliness because I think that's the most important. The rest doesn't really matter if the timeliness isn't satisfied here. The lower court held that there had to be some anchoring event that occurred after August 18th, 2019, based on the fact that the plaintiff received the right to sue on August 19th, 2020. The suit was filed August 18th, 2021. And one of the issues with establishing an anchoring event, here we have a constructive discharge claim. Ms. Andersen resigned from her employment on August 30th, 2019. If in employment cases, a constructive discharge is a resignation that is the result of constructive discharge is considered a discriminatory act. Therefore, if this court finds that she was, or the court found that she was constructively discharged, which was not decided, then that would be an anchoring act that would allow for the continuing violations doctrine to provide those other prior occurrences to be part of the present claim. And one thing that I think is very interesting is that as part of the constructive discharge claim on August 7th and August 8th, and then I think again on August 13th, Ms. Andersen was informed that she was not going to be eligible for the accommodation of reassignment because otherwise she was able to perform the essential functions of her job. Ms. Andersen suffered from mental illness. She was dealing with her mental health. She had major depression, anxiety, panic attacks, especially triggered while at work because of the nature of the work that she was doing, as well as the conduct from her supervisor that she perceived as discriminatory and harassing, such as calling her stupid and asking her if there was something wrong with her brain after she had just disclosed these disabilities that she was struggling with, heightened scrutiny with her work product, discipline, that sort of thing. And this case really brought to mind to me some correlation or parallels with the Burnett v. Ocean Properties case, where in that case, the plaintiff, who was wheelchair bound, was able to perform the essential functions of his job. And the defense argued that even though he needed an accommodation that would allow him to enter the building in his wheelchair without difficulty, he was at times late because he couldn't open the door.
Question for you. In order for Ms. Andersen's departure to be considered a constructive discharge, doesn't she have to demonstrate that some act constituting a hostile work environment occurred within the 2 years prior to the filing of the complaint?
I don't think so, because the courts have held, and I have Gonzalez Garcia, and that's 214 F sub 2D at 204, They held that when a resignation constitutes a constructive discharge, it is considered a discriminatory act on its own. So given the fact that that's a discriminatory act, that's an anchoring event that would...
But even if it's, you keep talking about an anchoring event and it's a discriminatory act on its own, even accepting that, the Morgan factors that were outlined in National Railroad Passenger Corp versus Morgan in 2002, those are the factors that the U.S. Supreme Court used to discuss when it's a continuing violation, when something occurs within the statute of limitations and other acts are without. Do you agree that that's the test that gets applied?
I do agree that that's the test, but I think, again, going back to the Burnett case, that because Ms. Andersen was saying that she could not even go into the building without panic, anxiety, these issues of depression, that she needed a reassignment. Just because she could technically do all of the essential functions of her job.
What about the point you said in footnote 1 in your reply brief, where you concede that the unwillingness to reassign Andersen was not a continuing violation? Note 1 in your reply.
I think that was Attorney LaRanger's reply brief. I did not write that. I don't know that I agree with that. I do think
But
that...
you're bound by it, aren't you?
Yeah. I think that the decision not to transfer her was absolutely part of the continuing violation, because at that same time...
Well, that is directly contrary to the concession in the reply, correct?
I mean, because at the same time that she said that, she said, because we looked into the complaints that you had about your supervisor and the statements you say that she made, and she did not make those.
I believe that perhaps he conceded that because a reassignment is a last resort under employment law, and you have to show that there are lots of other things that you do instead of reassignment. And so I think perhaps the reassignment, what you have to show that reassignment was required is pretty high bar that isn't reflected in this record.
Well, again, that's going back to the Burnett case. Was it accessible to her? I understand that in the Burnett case it was a physical disability. Here we're dealing with a mental disability, but it still has the same issues of making the workplace inaccessible to her. She could not physically go into the workplace without then having the anxiety attacks and the panic attacks that she was experiencing.
I'm a little confused here. Are you connecting this event or this incident in August where she couldn't go back in? Are you connecting that back to the hostile work, to the behaviors and the conduct earlier that comprised the hostile work environment? Or are you saying that this is a separate, discrete, independently actionable event?
I'm saying it relates back because she had made these prior complaints. So in that same conversation where she said, you're not eligible for reassignment, she said, we looked into your complaints of the hostile work environment and didn't find anything. Well, there's no evidence.
Isn't one of the Morgan factors that it has to be perpetrated by the same individuals, the same managers? And aren't we talking about two different groups of people here?
I don't think that it has to be by the same managers because it was a concerted effort. You have the
second, the final incident that you're referring to, the so-called constructive discharge, had nothing to do with the managers who were involved in the alleged hostile work environment, right?
That's correct, but there is a requirement with a hostile work environment that management for the employer take on the duty of appropriately responding to these complaints of harassment, and if they fail to do that, then that applies to the hostile work environment.
What's the evidence that she was being harassed because of her disability?
She informed her supervisor that she was struggling with anxiety and depression shortly.
Okay, she tells them, I'm stressed.
Shortly after that, she is told there's something that's wrong with her head. I mean, I think everybody here could interpret that reasonably to be a derogatory statement based on her mental health. She's then called stupid, called a liar, she's disciplined, she's scrutinized, she's moved so that they can keep a closer eye on her, she's yelled at and berated in front of all of her coworkers so loudly that everybody could hear her, sending her into a panic
What is
attack.
the evidence that all of that terrible behavior, and we can all agree that's not a good way to manage somebody, was on account of her disability as opposed to simply bad management?
For 13 years, she was working for the state of Maine without issue. Suddenly, the timing of everything that occurred, she notifies her supervisor of her mental health issues, and suddenly she's being called names, being berated. And I think there's a connotation of, you know, if she's being told there's something wrong in her head and she's having mental health issues, that is based on her disability.
But what's the discriminatory act at that point? I mean, obviously the managers here, or a particular manager, was being overbearing and inappropriate prior to any suggestion of her disabilities, which are in fact disabilities. There's no way that manager could have been discriminating based upon knowledge of those conditions before the fact. And as I understand it, the discriminatory factor you're keying in on here is constructive discharge, which occurred later, and you're trying to link the two together, and I'm having difficulty finding a nexus between, we'll call it just bad behavior by managers, and the fact that she decided to resign while she wasn't actually working.
Well, I guess, so the berating and the name calling, all of that occurred shortly after she notified her supervisor of her mental health issues at the time. And then when she resigned, it's because two reasons. She was told that they investigated her complaints, which there's no evidence that they actually did investigate her complaints because the supervisor admitted that she made those derogatory statements to her. So there's a failure on the employer's part to actually take the corrective action necessary.
And just, can you clarify for me? My understanding is she resigned because she was not going to be transferred to a place away from that particular supervisor.
Or to have that supervisor appropriately disciplined, removed from supervisory position, whatever disciplinary action the state thought it should take so that that action stopped.
But isn't that a disfavored, I think I read somewhere that an accommodation wouldn't include taking a person away from a particular supervisor who may be overbearing, that there may be other accommodations that can take place there? I mean, in looking at this, it looks like some behaviors by the employers may have triggered the conditions she had. But I'm having trouble flipping that over to say, okay, so she has this condition and she can't go back to work because it's the same person.
Well, I think it was multi-factored. She couldn't go back to work because of working with that supervisor. The state had ample time to respond to her complaints of discrimination before she even went out on leave and failed to do so. Failed to do so over the 6 months that she was out on leave. But also, prior to even the derogatory comments being made, she disclosed that she was struggling with the type of work that she was doing because of her mental health issues.
Did that take place before or after August 18, 2019, the disclosure?
Before. Yeah.
So you can kind of pull that into the statute of limitations issue?
Really, the only saving anchoring event is the date of her resignation being a separate discriminatory act as an anchoring event.
Thank you. Carter, we're happy to hear your argument.
Good afternoon, Your Honors. My name is Jeremy Carter, Assistant Attorney General representing the Maine DHHS. As an initial matter, just to discuss a few things that were raised in Ms. Quinlan's argument. First of all, this talk about, I believe she said, Burnett versus Ocean Properties. She was trying to discuss the reasonable accommodation or the failure to accommodate aspect of this claim. And we agree with the court's questions that were raised to that footnote 1 in the reply brief on page 5 has essentially put that question to rest. They conceded that the failure to accommodate that they were arguing that the Superior Court found was not an issue here, that the Superior Court was right. So any discussion about failure to accommodate, should she have been reassigned, was she entitled to a new supervisor, we see that as having been settled by the Superior Court and Ms. Andersen having not challenged that through that concession in her reply brief. Secondly, Ms. Quinlan stated that the issue of whether or not the constructive discharge, as Andersen is alleging it, could serve as the anchoring event for a continuing violation theory. She said that hasn't been decided. That's not, or that it wasn't decided by the lower court. It has been, it was. Otherwise, judgment wouldn't have been granted in our favor. The lower court ruled that where all other actions contributing to the hostile work environment that would have led to the constructive discharge were either deemed not to be unlawful, such as the failure to accommodate, or were deemed to have been within, or outside the statute of limitations, which is everything prior to August 18th, 2019, then the constructive discharge there could not be the basis for an employer's liability, DHHS's liability. So those two claims were, so that idea of whether or not constructive discharge could serve as an anchoring event to essentially spare this claim from the statute of limitations, because virtually everything else is outside, the Superior Court did rule on that. The Superior Court rightly concluded that no actions before August 19th are appropriately considered because of the time bar in the Maine Human Rights Act, and that any actions that took place afterwards or that Ms. Andersen experienced were not the independent basis for a cause of action here. And I'm happy to take the court's questions.
Do you acknowledge that the department was aware, or perhaps should have been aware, that Ms. Andersen was suffering from a disability in the form of anxiety attacks, panic attacks, etc., prior to her departure in January 2019?
No, Your Honor, we don't concede that at all. We actually think that the record evidence suggests just the opposite. In deposition, Ms. Andersen was asked, when were you diagnosed with anxiety disorder? When were you diagnosed with depression? And she said, I don't remember. I asked, was it before or after you went out on leave in January? She said, I don't remember.
Does it require an actual diagnosis, or is it sufficient that she notified, and I think she did before that, her supervisor that she was feeling stressed, depressed, in other words, may not have been an official diagnosis, may not have been under treatment, but certainly she expressed to her supervisor that she was experiencing these feelings.
I think the case law states that an employer has to be clearly charged with knowledge of an employee's disability. Clearly charged. It can't be a vague or conclusory statement about some unspecified.
Doesn't that at least, I understand that still may leave the statute of limitations question, but doesn't that at least raise a fact question? You may win ultimately, but doesn't that at least raise a fact question as to whether the employer was put on notice?
I don't think so. I think it would be very difficult for a reasonable jury to conclude and ascribe knowledge to an employer about a disability or a symptom of a disability when Ms. Andersen herself can't even specifically remember when that was. When she can't even get on the stand and say, this is when I was diagnosed, this is when I told my employer. We know for certain we learned about it once she started submitting ADA paperwork, but that was once she was on leave in the summer, or FMLA paperwork.
In addition to the way in which she alleges she was treated by her direct supervisor, and there's really another component to this, isn't there, which is that there certainly are allegations that the department did not act appropriately in following up once it did have the reports. In fact, there was even, I think, one of the folks who attended in the HR department was like, is anybody following up, doing an investigation, et cetera? I mean, isn't that really part of the claim as well? And that goes to what is an appropriate accommodation or way to handle this if they're not even going to follow up and investigate?
Well, a few points on the investigation question. I would say first that Ms. Andersen was interviewed after she raised those claims. She didn't make those claims until she was out on leave in the summer of 2019, maybe late spring, and she was interviewed by an HR manager. Now, this was a long time ago, and many of the HR people deposed didn't specifically remember what happened. But it should also be noted that not every complaint necessarily necessitates an investigation. Like I believe some questions were mentioned earlier, there are some times where there can be mistreatment, and we deny that mistreatment for the record, but even if it's true, it might not be because of a disability. It might not be based on a protected category. And if it is, that doesn't implicate the harassment policy the same way.
It does look like there was sort of a failure to follow through with the investigation about what actually happened.
Well, I think the facts that have been revealed since then suggest that if an investigation had been done, the same finding could have been reached that this wasn't an issue of harassment. Ms. Andersen has not made the claim that this was harassment based on disability really until she filed her complaint with the Maine Human Rights Commission. So even when she was making complaints or asking about the investigation in the summer of 2019, she never suggested it was because of her disability, because of some animus they had towards her as a patient with major depressive disorder or anxiety disorder. It was, my boss doesn't like me, I don't get along with her, she's making my life miserable, can you do something about it? She never alleged disability discrimination until after she resigned voluntarily.
Well, what is your explanation of the evidence that one of the DHH people said, you know, I didn't want to do this to you, I was told to squeeze you. What does that mean?
Well, Your Honor, we don't believe that that happened. It sounds frankly outlandish and slightly conspiratorial.
Summary judgment.
Well, I know, I understand that, but I was just about to say, even if it happened, there's no indication that I was told to squeeze you. Even if it happened, I was told to squeeze you. That doesn't relate to disability discrimination. You know, she could have upset the wrong person.
So
she could have. And
I was told to squeeze you because we want to get rid of you, and what? Because you can't handle this workload, not because you are suffering from a disability within the meaning of the definition for discrimination.
I'm just saying that even if we accept it as true that Ms. Sargent said that to her, you're right, there are different definitions that could be had, but it itself is not evidence of disability discrimination, particularly given, this again goes back to Ms. Andersen's deposition. When I asked her in the deposition, why do you think this was happening to you? Why do you think they were doing this to you? And she said, I think it had to do with the email mistake I had made. Now that is briefed about, it's in the facts in both briefs. Ms. Andersen made a mistake, a pretty big one, where she disclosed a lot of confidential information to people she shouldn't have. And when I asked her, why do you think Ms. Sargent was so upset with you? Why do you think around this time in late 2018, Ms. Sargent started giving you a hard time? She said, the email incident. And I said, any other reason? And she said, no. So even as late as her deposition, Ms. Andersen was not claiming that the conduct, bad though it was, accepting it as true for the purposes of this posture, she never claimed or alleged that it was about animus towards her disability, that it was about Ms. Sargent saying, I'm not, you know.
Let's go into hypo land, okay?
Sure.
So start with you're an employer, and it's a work environment in which the employer imposes a heavy workload level on its employees. That's not in itself a hostile work environment, right? It may be unpleasant, but it's not an actionable hostile work environment. Yes or no?
I would say no. I don't think that would.
All right. Then what happens, one of the employees tells the employer that the workload is really stressful. And does that transform it into a hostile work environment?
No, Your Honor.
Okay. What if the employer decides that it wants the employee to leave because she can't handle the workload? And so they're mean to her, they give her more work than ever. Is that a hostile work environment?
If in the hypo they were doing it because the employee had a disability and they didn't want to deal with that disability, then potentially.
If it's because they want to get rid of her because she can't handle the workload, that's okay, that's not actionable. If they are trying to get rid of her because she has told them it's a disability and they want to get rid of her because of the disability, then it's actionable.
Well, wanting to terminate someone because they have a disability would be presumptively actionable under the Maine Human Rights Act, yes.
Well, what about the brain comment?
Again, well, we deny that the brain comment happened, but assuming that it did, assuming that the brain comment was made, I think this court has a fairly analogous case in Doyle. Doyle dealt with a question of hostile work environment based on disability, wherein there was no dispute in the record that the employer was aware of the employee's disability and made a rather crass, quite disgusting, rude comment about it to the employee's face. And this court ruled that unpleasant though it was, unprofessional though it was, that type of comment, even directed with intent at the disability, does not meet the severe or pervasive standard of a hostile work environment. I think the same can be said here. Even if these two comments about having something wrong with your brain or potentially being a liar, I think even those two comments are isolated enough. They're not merely they're offensive utterances, they're not repeated, they aren't intense, they're passing comments. This is all language that courts have used to say, yes, sometimes people say nasty, terrible things at work, but the severe and pervasive standard means something. And one or two passing comments, even if said, don't seem to rise to the level of severe and pervasive misconduct that this court and others have recognized as being necessary to satisfy a hostile work environment standard.
We're talking about the summary judgment level, correct?
Yes.
So if we have conduct in which the employee is feeling stressed from their workload, tells them, I've got a disability, and then they lard on more workload, is that enough to, and they're mean and they say terrible things about her, is that enough to get you over the summary judgment hump?
I think that would depend on what evidence they had to suggest that the piling up with work, the being mean, was based on the disability. If there was evidence to say that they were doing it because of her disability, because they believed her disability prevented or precluded her from doing the work, I think you'd probably have evidence.
So the timing is not enough?
I'm sorry, Your Honor?
Timing would not be enough. That she tells them about the disability, and then they start being mean or they continue being mean. That's not enough to get past summary judgment.
Potentially relevant, but I don't think it would be dispositive because timing alone wouldn't necessarily be evidence that would allow a reason.
Would it raise a fact question?
Well, yes, it might raise a fact question, but even still, there is still a threshold by which the evidence should rise to the level of a fact question, an issue in legitimate dispute, a legitimate issue of dispute on which a reasonable jury could essentially find either way. That wouldn't be the case, I think, if you only had the timing alone. And again, what we're dealing with here is not just, sort of a timing question. There's a serious lack of information that anyone knew she had a disability. She worked with foster children in the care system. It was a stressful job. That job has high turnover. You experience people sometimes at their lowest lows, their worst worsts. And it's a stressful job, particularly given how kids are involved. If our employers, if our managers there started saying every time someone said, I'm stressed out, well, pump the brakes. Does that mean this person is disabled? That's just not rational. That would be sort of the vague, sweeping, conclusory statements that courts have said do not put employers on notice. Yes, Ms. Andersen was stressed out. She had a very stressful job. It's not a fun job. And her supervisors were aware that she was stressed. But to say that that puts them on notice that she has an anxiety disorder or a depressive disorder, and they then acted because of that, out of animus towards that disability, to drive her out when the record is replete with evidence of other reasons why she might have been getting disciplined.
So your point is that no jury could make an inference that they have notice of the diagnosis, and it's a disability, and they've previously said to her, there's something wrong with your brain, and then they refuse to accommodate her request. You're saying no jury could infer from that there was a discriminatory animus behind the scenes there?
I don't think so, Your Honor. The record is replete with evidence that suggests why those things were done. They're not pretextual. They aren't challenged as pretextual. And the fact that there has to be some notice to the employer.
So if a jury made a finding of discriminatory animus and a discriminatory act, that would be set aside on a directed verdict, or the judge would step in if the jury drew an inference of discrimination there based upon those facts that we know exist.
Well, if that were to happen in this case, we might make that argument, because the evidence there to infer animus here, there really isn't any link. If I may finish, Your Honor. The point.
Finish your sentence.
Yep. There really is no link here. Why all of a sudden did they have this animus towards Miss Anderson's disability? It's never explained. It's not justified. It also happened to coincide with the time that she made a pretty severe error at work that exposed confidential information.
Thank you.
Thank you, Your Honor.
Attorney Quinlan, I believe you reserved 2 minutes for rebuttal.
Yeah.
Can I ask a question? When you've indicated that the resignation on August 30th, 2019 is essentially the anchoring act, that was a constructive discharge. Let's assume that to be the case, that it could have been construed as a constructive discharge. Isn't there a problem here with the timing? In other words, how can you extend the statute of limitations indefinitely? She was out on medical leave essentially since January, so for approximately 7 months. Am I right? Before she resigned.
Yes, you're correct that she was out on medical leave for about 7 months, but I believe it was August 13th when she was last informed by Kate Wentworth. We've investigated your complaints.
But she wasn't given an ultimatum, come back now or you're terminated.
She wasn't given an ultimatum, come back now or you're terminated, but it was go back to this environment where you believe you're being discriminated.
I understand they weren't going to offer her the accommodation that she wanted,
Right.
and that may have been the triggering event. But it appears on these facts she could have stayed out on medical leave almost indefinitely, certainly for longer than she did. They weren't pulling her back in. I mean, can she indefinitely extend the statute of limitations even though she's not on the workplace by staying out on medical leave before she resigns?
No, so for constructive discharge, the courts have held that it must be a resignation within a reasonable amount of time after some condition has occurred that makes it intolerable or unsafe or would adversely affect your health to return to work. And that is the case here. If she had returned to work, she would have been forced to go back to this environment where they weren't going to accommodate her, weren't going to take her complaints seriously, weren't going to investigate, weren't going to discipline the supervisor making these discriminatory complaints. And just going back to some of the issues that were brought up prior to her going out on leave, the supervisor was going to have to call an ambulance because of the panic attack. The fact that Ms. Andersen couldn't provide a date in her deposition for when her diagnosis occurred doesn't really go into the analysis because it's this regarded as disabled. She was clearly suffering mentally. It's something that occurs in their field frequently, this high burnout rate, and she made statements, what's wrong with your brain?
Thank you, counsel.
Thank you.
As we generally do, we will take the matter under advisement and issue a written decision in due course. I do note, Attorney Carter, this appears to be your first appearance in front of this court, and our usual practice is to invite counsel back to chambers to take the greetings of the court. So we'll see you there.
All ayes. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting in the law court, may hence depart and give their attendance here at 10:40 a.m. tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.